this situation, we have a complaint by the regional director, and I guess I'm a little confused as to why you think, or your brief suggests, that that's irrelevant to the issue of whether or not there is an arguable protected scenario here.
Yeah, sure, for two reasons, Your Honor. First, theoretical, and second, from the case law. The theoretical reason is that the board's overriding interest is ensuring a legally uniform interpretation of the NLRA. That's why its interest is sufficient to override the state's interest in adjudicating a tort claim where the actual facts are arguably protected. The board then gets to determine whether the actual facts are actually protected as opposed to arguably protected. Second is the case law reason. Bill Johnson.
I'm sorry, I'm not sure that I understood the reasons for arguably protected in the same way. I thought arguably protected was our recognition of Congress's intent to allow the board to take first crack at these kinds of scenarios. So what we say is, as long as it is possible, it is arguable that we have protected conduct here, then the states need to stand down and allow the board to go forward. So I hear you sort of suggesting that the states can get to make that initial determination about arguable, and that's not how I understood what was happening.
Well, Your Honor, I think I do have a slightly different understanding of it than you do. The states always, almost always in these cases, make the threshold determination as to whether the alleged facts are arguably protected under the
Just because
NLRA.
there's going to be a dispute about whether or not they should step aside, not because they inherently are the ones to make that determination.
Sure, and I think that the way I understand Garment, at least, is that when you've got a set of facts, and on those facts, there's an arguable conflict with the federal statute, it's the board that gets first crack at determining whether it's in fact an actual conflict.
But the board does not, but the board's assessment by the filing of a complaint that here we arguably, this is the regional director and the general counsel, they've looked at all the facts, and they file a complaint which indicates that someone has made an initial assessment along the same lines as arguable that we have protected conduct here.
Right.
I don't understand why the easiest way for all of us to be looking at this is in this particular kind of scenario where we have a complaint, then the issue of arguable is satisfied, and we allow the board to continue to investigate, and it can reach the actual determination that you're talking about.
I think it's because we'd be taking the extraordinary step of ousting a state court of jurisdiction to adjudicate a state tort complaint that on its face alleges facts that, as all agree, aren't even arguably protected.
The government says that all